Welcome to the Capital Forum's 7th Antitrust Thought Leaders interview series sponsored by KL Discovery. My name is David Blotner, and we are delighted to have David Reichenberg here with us today. David's a partner at Cozen O'Connor and has represented many major tech companies. Thank you very much for joining us today.
Thanks for having me, David.
So because you represent or have represented a bunch of tech companies, we're going to talk about tech today.
Sure.
So one of the hottest topics these days is how to apply antitrust law developed over the last 100 years to today's tech companies, and particularly the large tech companies. So how do you sort of think we should approach that kind of issue?
Sure. So I give our antitrust laws a lot of credit. I think despite the fact that they were originated 100 years ago, what it really was setting up was a rubric to analyze future industries, future markets that couldn't have been in the minds of the framers back in early 1900s. So over the course of my career, I've not only looked at tech, but I've looked at toilet seats, IP rights, video games, retail products. The tools that the antitrust laws provide are fact-specific and contextual tools that allow you to assess the given competitive dynamics in a given market. And so when I think about tech generally, and when I see a lot of commentary these days, it seems to be talking very generally about, well, do the tools need to change and do the metrics need to change? I have not seen any evidence that the tools are inadequate to address the issues. And to me, the question is, what conduct, if any, are people going to address their sights on? And once you identify the conduct, then that frames what markets, what tools, what alleged anti-competitive effects go into that. And so in the abstract, and to say that our tools need to change, our approach needs to change, seems at best premature to me before we know what we're alleging as the problem.
Okay. Well, then let's try and talk about some of the more specific applications. So, a lot of the tech mergers that we're looking at don't really involve physical assets anymore. They involve intellectual property. They involve just things that are not the kinds of things that they were thinking about when they passed the antitrust laws over 100 years ago. So, how do you think that affects how we should think about the competition issues? And we're not talking about physical goods and services, or physical goods. We're talking more about services these days. So how do we sort of adjust our thought process or our analytical process to deal with that?
Sure. So, I mean, they're still products and services by and large. So instead of dealing with paper or oil, as you said, we're dealing with rights or IP rights or R&D. Markets are dynamic. We have economists and industry experts and data where you can analyze concentration, whether it is a physical good or it is in a more abstract concept like the collection of IP rights. The key is, as an economist would say, what are the substitutes or reasonably interchangeable substitutes for the thing that you're talking about, and thus do those provide a constraint on a hypothetical monopolist having market power over a given area. So while someone may have a patent, for instance, are there over-the-counter on a drug, for instance? Are there over-the-counter substitutes for something that is not patented that's over-the-counter that serves a similar purpose? You've seen that in pharma cases where the allegation was the company has the patent, they have market power, they were able to raise prices or they were able to forestall competition, but then a court looked at the market very carefully and looked at the evidence and said, well, there's this OTC alternative, there are these other drugs that are combating this particular issue. And so when I hear you say, well, we're not dealing with goods, we're dealing with IP, to me the IP really isn't a process or a good. It is the designation of a particular type of process or specialized way of doing something that makes it special according to our IP laws. But fundamentally, we're looking at products and services and whether or not there's market power.
Well, for something like services, for example, how would you measure market power in a service? Is it based on the revenue, or is it based on the number of subscribers? What's the right metric that we should be using when we think about services?
So I'm trying to think of a good example, but a case that I worked on early in my career was Netflix online DVD rental sales. Is that a product or a service? It was the alleged product market was online rental of DVDs, whereby you clicked a button online, picked your movies, and this was before streaming was more developed. They were sent to you through the mail,
Right.
And that was a service. And the allegation was, well, there are no meaningful restraints on Netflix's. That was the allegation that we were luckily able to disprove. But there were no readily available substitutes for getting your DVDs through the mail in the case of a price increase. So I still would maintain that. What do you look at for a service? I think an economist would tell you. You want to look at consumer revenue. You want to look at barriers to entry. You want to look at the range of substitutes available for that service. I saw a complaint the other day that's alleging a monopoly over brokerage services or a conspiracy. I forget what either a conspiracy over brokerage services. Are there substitutes to people going out and selling their homes? And the answer to that in this economy might be yes. You can go onto Zillow and you can go into other areas where there are competitive constraints on that alleged service where there may not be market power for that service.
Although when you bring up Zillow, of course, some of their biggest clients are actual, physical real estate brokers, and they basically, sell advertising on their site to those brokers. That's one of the ways that they make money.
Sure, and I think that's an interesting dynamic, kind of a dance that's going on between. It's a good example of technology disrupting markets and providing more access to consumers. I think the traditional brokerages, well, they are going to go online. They are going to take advantage of this. I might as well get in on this game and create a deal where it makes sense for brokerage to keep doing what they've been doing, but also allowing themselves to market themselves online and vice versa. And so technology is I would argue, on the whole, a great thing that gives people more options, gives people more alternatives, and people are figuring out how to position themselves in this new economy.
All right, so let's talk a little bit then about sort of a more specific antitrust example that doesn't really get much play these days because these cases are hard to do. But one of the interesting things to, I guess, think about is whether some of the new services like Facebook are really bundling or tying together two different products, and if should tying law sort of be applied to areas like that, and if so, how would we do it?
So I can't comment specifically on a particular case on Facebook. What I can say in general is tying and many other antitrust theories, I would argue, are based on coercion as the concept, which is that somebody wants something good won, but then allegedly you're being forced to take or coerced to take good or service along with that. And so there's been extensive case law about you have to have two distinct products. You need to have sufficient economic power in the tying product, sufficient amount of commerce in the tied product, and you need to apply that to a given case. It really provides interesting examples of, well, is one good distinct from another, or are they bound up into one? To pivot slightly from your question, I think actually coercion, the word is used very specifically in the tying concept, and is also used in the exclusive dealing concept. But I actually think it's a concept, well, no one has ever formally named it, I think correctly, a formal element of an antitrust violation. I really think it is the thing that people are looking for in most antitrust cases, and I would articulate it this way. Coercion, you don't want coercion to occur where consumers are being forced to buy something or take something where they shouldn't have had to in the presence of competition. So the idea being in tying, you wouldn't have had to take good too. But more abstractly, if you apply that to price fixing, in the presence of competition between the competing horizontal suppliers, consumers shouldn't have been essentially forced to take the good at that artificially high price. So I think the story that plaintiffs, I've done work on both the plaintiff and the defense side, the story that you want to be telling is people are being forced to do or to take something that they could have benefited from greater competition from. And the story is that that competition was somehow impeded by the person who allegedly coerced you into taking it.
So is there a more concrete example that you can give us of where you think that would apply?
Sure. Let me think for a second. I think a case that I worked on, an exclusive dealing case, was this. I think we alleged it to be in the bundling context. So if you've ever been to a grocery store,
right,
there are towers at the front of the store. They're called EAS towers, or electronic article surveillance, and those towers beep when somebody tries to shoplift a can of gel from inside the retailer drugstore, and the little sticker on that gel is referred to as a EAS label or tag, but usually label. So the allegation that we made in this case was that the retailers could only get the towers at the front of the store that could set off from one particular company, and they said, well, we'll actually give you the towers. They said to powerful retailers, we'll give you the towers for free, but you have to buy all your labels and everything else from us.
Sure.
For which and we argued this was a bundling violation. And there the premise was you are essentially being forced to take the competitive product because of the incredible deal that they're giving you on the thing that you need from the monopolist. So, and then that gets into the whole commentary on peace health and what the proper standard is for such conduct. But really, what it's after are people being coerced into something that is harming competition in the long run.
Okay, so I mean, I was trying to think of another sort of tech example that we could sort of talk about where, I mean, a lot of the tech examples that we think about are where you have to give up some information in return for getting, some other, service that you want to access, whether it's a search that you're doing on Google or Microsoft Bing, but in some way you're giving up information, and in return you get this search result that you're interested in. Is that something that you think should be thought about in the tying context, or is that sort of not helpful, you think?
I don't think tying, as it's formulated in the case law, I'm having a tough time interposing the two distinct goods. You're being forced to take one. You're essentially being coerced into taking something you do want. I guess the argument would be you're being forced to give your information
in return for having to sort of look at a bunch of ads.
I don't know that we've applied tying to the giving of. You're not being forced to take. It's usually in the other direction.
Right. You're normally buying something.
But I guess, this is why a lot of these issues cross over into privacy, as you can imagine, which is this something that should the collection of this information be permitted, regardless of its effects on the market? That's why I think privacy is one ledge, an analytical tool, antitrust is another, antitrust and analytical tool. So again, going back to my opening comment, you really need to look for, what is the conduct that you are alleging. If the conduct you're alleging is you're not allowed to give away a free service if you're putting this on the other end, it's a tougher argument in the antitrust context because you have output expanding, innovation expanding, optionality expanding. There's a reason why all these people are signing up for these services. So it's tough, but then you have privacy people. Well, notwithstanding no clear harm to competition, we have a privacy issue, and that's why people are looking at it from that from that vantage point. Again, I think as somebody who's practiced again on the plaintiff and defense side, you need to have a theory of harm. You need to have conduct. You need to have a theory of harm. You need to explain how that practice lessened competition and harmed consumers. In the abstract, it's really hard to wrap your head around these things.
And some of these markets are sort of the kind of markets that have network effects in them, and so you would expect if a company is going to succeed, these network effects are very important, and that's just sort of the nature of the beast to a certain extent.
Whenever someone says networks effects to me, I think of Alexander Graham Bell and the telephone, and the utility of the telephone goes up with each additional user. Are we gonna blame the innovator of the telephone that the utility increases? At the same time, that doesn't mean it completely immunizes you, because those network effects occur. But you need to look at. Are there benefits associated with those network effects? Or is there something being done to allegedly take advantage of those network effects to foreclose cell phones to compete with Alexander Graham Bell?
Yeah. Well, again, this is sort of when the wireless technology overtook the wired technology in a lot of ways, and sort of eliminated some of the concerns that people had about the Bell companies and the amount of power that they had, and that was a technology thing. But in the meantime, the Bell companies did do a lot of things to inhibit competition, and along the way, which led to the original AT&T case from almost a generation ago, I guess, at this point.
I think that's right.
Yeah,
back when I was in grade school, but yes.
Go ahead, make me feel old.
No,
make me feel old. All right. I guess the last question I had is, do you think there should be a higher bar for large tech companies that are trying to buy smaller potential rivals? Or do you think the merger laws as they exist and the way they're being applied is adequate to address that concern?
I mean, perhaps there's no more area of antitrust, I think, that is fact-specific, because it is fundamentally a predictive exercise as to why. I mean, every deal that I've come across or that I've counseled on, it's, what truly is the reason for this deal? The antitrust lawyers want to look at the 4C documents, which are the documents that need to be turned over, but really, what is the there? What is the competitive justification? What value is one company providing to another? And on that, you really need to dig into the specifics of a market and who the players are and who the entrants are, and you're making educated decisions. And I don't necessarily think, I haven't seen evidence that a higher bar for a particular industry is necessary. The substantial harm to competition standard and the consumer welfare standard seem to be adequate. I think what you might really be asking is, should we be looking more critically at potential tech acquisitions? And the answer to that is potentially, because of deals that have network effects or sole supplier effects and other things. And it's common, as we know, for there to be risk sharing provisions and merger agreements that are really setting a barometer for the antitrust risk of the deal. And so we've seen a lot of challenges. We've seen a few challenges in tech and extensive investigations in tech, but I don't think, again, inherently people should hear the word tech and say, oh, we need to change things. But it might lead to more enforcement and more need for more resources in this area.
I guess the question is there a different way that we should evaluate those kinds of deals? And I guess you're saying you don't see a need to evaluate them differently?
Well, I think it's semantics, but every deal is analyzed differently depending on who the parties at issue are, who the competitors are, what the market is. So when I hear you say differently, I think of, do we need a different legal standard by which that overlays the entire facts? But every deal's facts, as we saw with the challenges to, Office Depot, the same transaction could look supposedly look very different in year 10 than it looked in year 1. And so that was a different case, despite the fact that they were the same parties.
Right. Better evidence the first time around is probably the answer. But I guess I'm just trying to push you a little bit on the tech end of it, though. Is there something you think we should be looking at differently or evaluating differently with tech than other kind of mergers? Because, as you say, it's a difficult predictive process, regardless of the industry that you're looking at, and the ability of antitrust lawyers and enforcers to predict the future. No reason to think that they're any better than anybody else, and maybe they're worse at predicting the future. So that's always the exercise we're engaged in. But with tech, we seem to have sort of come to a point where people think that we haven't, that the antitrust laws haven't been enforced appropriately, and that's why we've got into the situation that we're in with all these sort of giant tech companies these days. So going forward, is there a different way you think we should evaluate tech mergers? Or a different way we need to think about tech platforms?
I mean, I'll put it this way: there are these network effects, and there are, the better a product is in tech, the many millions of users are going to use it, and so there's an argument there, or there's a susceptibility to when you have so many people allegedly dependent on a platform, and I put quotes around it because, every other week, my 6-year-old will come up with a new app that I'm convinced will replace, one of the social networks in the next 5 years. But we don't know that. So you need to look at the network effect. You need to look at the stickiness of a given technology and say, is this going to increase the stickiness? Are there going to be coerced consumers that are forced to take price increases because there isn't competition in some area that these two tech companies cover? I think another area that makes tech so difficult is tech companies are multifaceted and are in many different markets, and it's hard to define those markets. Right. But I think then there's a need, and we're seeing it from the FTC and the DOJ, particularly the FTC with its task force, is dedicating more resources to understanding all the varied markets that these companies are in. So I think you can get me to say that they're difficult. They need to be looked at carefully with their unique facts, but I'm not prepared to say that a totally different standard, welfare standard, or a change of the laws is needed.
Okay. Well, thank you very much. Appreciate you doing the interview with us today.
Thanks, David.